Welcome back to the Constitutional Clarion. It's been reported in the media that there's a battle going on outside a pre-poll voting centre in the electorate of Kuong. Apparently, a political party has put up a wall of A-frame and Corflute political advertisements to the exclusion of most of the other parties and candidates. It's been claimed that there were so many of these along a busy road, which has a tram line as well, that it's become a safety risk as well as raising issues of fairness. The local council alerted parties to a local planning law which stated that a person must not, without a permit, place any advertising sign on council-controlled land or a road. The council said that it would issue a permit for one A-frame sign only per political party. The party that had erected these signs then had a lawyer write to the council arguing that it did not have the ability to regulate electoral signage and advertising in the vicinity of a polling booth, or indeed the number of volunteers that are in attendance outside the polling booth. It added, "Our client views the council's conduct as unlawful and an impermissible burden on the implied constitutional freedom of political communication. Our client does not intend to comply with the restrictions." It went on to demand that the restrictions be withdrawn in writing by 3 p.m. today, or their client will apply to a court for an urgent injunction restraining the council from putting such a permit system in place. So, is there any basis to this? What powers do councils have to deal with political signage? This is an issue that's actually been addressed a number of times by the courts. But first, a little background on the freedom of political communication. The High Court has recognised that the Commonwealth Constitution contains an implied freedom of political communication. This is because Sections 7 and 24 of the Constitution require that the Houses of Parliament be directly chosen by the people. The people cannot make a genuine choice if they are denied the capacity to engage in political communication and receive information about candidates and parties and policies. Political advertisements, therefore, fall within the core of what the implied freedom protects. But the implied freedom is not absolute in its application. Laws that impose limits on political communication, such as local council planning laws that limit the display of advertisements, can still be valid if they are done for a legitimate end, consistent with the democratic system of government, and the law is reasonably appropriate and adapted to serve that legitimate end in a proportionate manner. For example, in Becker and the City of Onkaparinga in 2010, the full court of the Supreme Court of South Australia upheld the validity of planning laws regarding the display of signs on residential property, finding that they were reasonably appropriate and adapted to achieve a legitimate end concerning orderly and efficient planning and development in the state, visual amenity and public safety. Requiring development approval for such signs was reasonably appropriate and adapted to serving a legitimate objective, according to the court. In another case in Western Australia, a supporter of the West Australian Party, Ms. Van Lieshout, sought to overturn her conviction for placing political advertisements on a fence in breach of development laws. She challenged the validity of the laws concerning the placement of signs on the basis that it breached the implied freedom of political communication. She also argued that the City of Fremantle was not a legal entity because there was no provision for local government in the Commonwealth Constitution and because the 1988 referendum had rejected constitutional recognition of local government. Now, that particular argument was rejected by the Western Australian Supreme Court in Van Lieshout and the City of Fremantle in 2013 as being without merit. The court noted that such an argument about the validity of local government had previously been dismissed in the Glue case, and that the High Court had in that case refused special leave to appeal on the ground that the argument was entirely lacking in legal merit, as indeed I have previously explained on other videos on this channel. As for the implied freedom claim, Justice Hall noted that it's not enough that the freedom is burdened. It must also breach the other parts of the relevant test. The reason that the signs breached the local planning laws was not because they contained political statements, but because they covered part of a fence that was required to be visually permeable. While the laws might burden the implied freedom, they had a legitimate object, being orderly development in the city, including the preservation of heritage value and streetscape. The laws were held to be reasonably appropriate and adapted to achieve a legitimate end in a manner that's compatible with the maintenance of the constitutionally prescribed system of government. They were therefore held to be valid, and any political advertising had to comply with them. A more recent case, which occurred in Victoria, concerned political signage erected in support of an independent candidate, Zoe Daniel, at the 2022 election. At the time the sign was erected, the election had not yet been called. After having received some complaints, the local council took the view that under the local planning laws, such signs could only be erected without a permit once the election had been called. This was challenged in the case of Badger and Bayside City Council in 2022. The challenge was directed at both the application of the planning laws to the political advertisements and whether the planning laws breached the implied freedom of political communication. Now, I won't go into the details of the planning laws here, but the take-out message is that they were actually quite poorly drafted and their application to political signage was very unclear. In the end, the court held that the laws applied in such a way that the political advertisement could be erected for 3 months. It was therefore unnecessary at that stage to decide the implied freedom point. But Justice Dixon did accept that signs identifying candidates for an election appear central to the implied freedom of political communication. His Honour also queried whether there might be an alternative, equally practicable measure which is less restrictive on the freedom, and that goes to the proportionality part of the test. So where does this leave us with a potential challenge to the local government planning laws in the Kuong electorate? First, it would depend upon the terms of the laws. If they are poorly drafted or their application has been misinterpreted, then a court may find that they do not apply or they apply in a more limited fashion. This would be a matter of statutory interpretation. But if they do apply, then what of the constitutional argument? Planning laws that restrict political signage would indeed burden the implied freedom. The question then would be whether there is a legitimate purpose or end for such restrictions. A purpose of protecting public safety for pedestrians and for traffic in a busy street would undoubtedly be a legitimate end. A purpose of achieving fairness by ensuring that a range of different political communications can be seen would also be likely to be regarded as legitimate. The High Court in the McCloy case took a similar approach in relation to laws that limit the rich from dominating political communication so as to allow a range of different voices to be heard. A purpose concerning the protection of visual amenity and heritage value, which is a common purpose when it comes to planning law, is also likely to be regarded as a legitimate purpose. But such a purpose may have a weaker effect when it comes to applying the next step in the test, which concerns proportionality. While election signs can be annoying and a visual blight, they are only there for a relatively short period of time. As Justice Martin said, in an application for an interlocutory injunction in Liberal Party, Western Australian Division, and the City of Armidale in 2013, amenity may need to give way to democracy and the democratic process, at least for the duration of an election campaign. The level of burden imposed by the restriction may be disproportionate to the benefits sought to be achieved in the legitimate end. Such matters would be for a court to determine in the circumstances, if it actually gets that far. It would seem more sensible to just avoid litigation by simply sharing the space and not encumbering others. Thank you once again for watching the Constitutional Clarion, and as always, I look forward to seeing you next time. Goodbye.